high courts. Because if everything would go to high court, then there are other matters in high court would get disturbed. The entire reason of tribunal is to reduce the burden on courts, to filter out the cases before it really goes to high court. Aggrieved can go for filing of an appeal before the tribunal. Very, very important is the time limit provided here is within 3 months. Within 3 months. 3 months from the date on which the order sought to be appealed against is communicated. Date on which the order sought to be appealed is communicated. And the communication term is given under section 169. Correct? Orders that are now passed already. What do? Because order to aa gaya, 3 mahina ho gaya. So are you filing? Tribunal is not formed. Then what are you doing? Condonation of delay. Condonation के लिए भी 3 ही महीना है, 6 महीना. फिर ऑर्डर आके 1 साल हो गया, अभी क्या करोगे? हाँ? Yes, yes. Government has come out with a circular clarification stating that you give a declaration stating that कि भाई हम लोग appeal file करेंगे tribunal में. Don't start the recovery proceedings. We are going to file appeal and make the payment of pre-deposit. To admit, refuse to admit if the amount does not exceed 50,000 rupees. They have this power. Chota mota abhi please mat aao. Cause objections. You should question what has led for the department to file an appeal. They would have to clarify on the legality or propriety. They can either confirm the order or they can modify the order. Let us say 1 crore is a demand. They can say no, out of 1 crore, 50 lakhs is proper. 50 lakhs is only the actual legitimate. So they can modify the order. They can annul, reject the department's plea or appellant's plea and pass the entire order as is, and or they can refer back the case. Very, very important. They can refer back the case with such directions as it may think fit for a fresh adjudication or decision. Timeline for orders. For tribunal to pass an order after we file an appeal, there is a time of within a period of 1 year from the date on which it is filed. If the amount is less than 50 lakhs and there is no question of law involved, then it is to be heard by a single member. That single member can be a technical member or a judicial member, but it has to be heard by a single member only. Whereas, let us say the amount is only 1 lakh rupees. The amount is only 1 lakh rupees, less than 50 lakhs. But it involves a question of law. It involves an interpretation of 17.5. It involves an interpretation on 16.2. It involves an interpretation on certain aspect. Even if it is less than 50 lakhs, the matter would still not be gone by only single member bench. It will be a 2-member bench. If both the members are active, listening properly, questioning and all those things, then there is a chances of difference of opinion. And if it is so, then the matter goes to a 3rd member. Inherent powers. They can use the inherent powers to give such orders or such directions as may be necessary for meeting the ends of justice or to prevent abuse of the process. Single show cause, multiple OIO, order in originals, and single OIA. You need to still file multiple appeals as per the OIO, not as per OIA. Very, very if authorized representative does not appear, then the tribunal can dismiss the appeal and decide it on merits. They can dismiss and decide it on merits. Later, if assessee is aggrieved by that order, they can actually file an application for interlocutory application for restoration of the appeal, and basis the sufficient cause. If it is satisfied, tribunal can restore that appeal which is dismissed, which was dismissed because you did not appear. Interlocutory application is to be done for that. I think there is something mentioned about the interlocutory application in the rules. I have not checked that. There's something mentioned about the interlocutory. There's a rule for that. I'll get back to you on that particular thing. So now this pronouncement of order within 30 days, it's important. Once the hearing is done, final hearing, they have to pronounce the order within 30 days, excluding vacation and holidays. Waiver of pre-deposit should not be sought as a matter of routine. See, tribunal mein what happens, once you are appearing regularly, and you are constantly asking for waiver, then the judge will start saying you. It can be sought only in cases of financial hardship or where procedural justice has been overlooked. So these are three important judgments. I would just want to cover key text of those judgments. It should be looked at only in rare and deserving cases where there is inadequate reasoning for penalties imposed. Department has not given any reasoning for the penalties imposed, and now you are asking me to deposit 10% of that penalty. There is no proper reasoning. Imposing pre-deposit would disable business operations. You need to prove it beyond, with proper clarity. Petitioners having very limited means to pay.